the board meeting to order for March 21st. First item, we have an agenda, and the first item on that agenda is to approve the agenda. I understand we're going to add one item to it. Steve, do you have that?
Yes, we're going to add an item 8A, and that'll be to have a joint meeting of the EDAB/Park Board set for Tuesday, April 12th at 5:30 PM at the Township Hall.
Okay. And we have to call this a special board meeting
Special board
because
meeting.
2 board members will be attending that.
Correct.
All right, is there a second?
I'll second.
Motion is made and seconded to call a special board meeting. Those in favor, please say aye.
Aye.
Any
That was
opposed?
to amend the agenda. So you just approved the agenda with that additional item.
So we'll come back to it later.
I'm in a hurry. I'm sorry. Okay.
Okay, let's come back to
The
it.
motion to call the special board meeting is, I'm sorry, to add the special board
Yeah,
meeting.
that's what
to
I
the
was
agenda.
doing.
And we voted aye on that, right?
Correct.
All right.
Joan knew that.
Joan knew that. All right. If there's no other changes to the agenda, is there a motion to approve the agenda as amended?
So moved.
Is there a second?
Second.
Motion's made and seconded to approve that agenda. Those in favor, please say aye.
Aye.
Any opposed? Is there, opposed, motion passes. Is there a motion to approve payment of bills?
So moved.
So,
Is there a second?
second.
Motion's made and seconded to approve payment of bills. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes. Minutes of the February 26th Special Town Board Goal-Setting Meeting. Any corrections or adjustments to that?
I didn't see any.
Otherwise, if not, if there's no adjustments, is there a motion to approve those minutes?
Motion to approve those minutes for the February 26th Special Town Board Goal-Setting Meeting.
Is there a second?
I'll second.
Motion's made and seconded. Those in favor, please say aye.
Aye.
Any opposed? Second set of minutes is for the town board meeting on March 7th, 2016. Any corrections or changes to that?
None noted.
Is there a motion to approve those minutes as submitted?
I'll move to approve.
Is there a second?
Second.
Okay, motion's been made to approve the March 7 board meeting minutes. Those in favor, please say aye.
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 Aye. Any opposed? All right, that motion's passed. We have 3 items on our consent agenda this evening. Steve, could you read those for us, please?
Yes. Consent agenda item 5A, in accordance with the Township's special event policy, grant non-exclusive use of Bel Air Beach to South Shore Trinity Lutheran Church, 2480 South Boulevard, to hold outdoor worship services, weather permitting, on June 5th and 19th, July 3rd, 17th, and 31st, August 7th and 21st, beginning at 9:45 a.m. for 2 hours per service, and to allow use of electricity from the Township Lifeguard Building to power the sound system. Consent agenda item 5B, based on town engineer's review and recommendation, and including his recommended conditions, approve XL Energy permit to install a gas and electric service for the resident at 5320 Bald Eagle Boulevard East. And the third item is to receive the construction activity report. A motion made to approve those consent agenda items.
Is there a second to approve?
I'll second the motion.
Unless there's no questions, I'll call for a vote. Those in favor of approving the consent agenda, please say aye.
Aye.
Any opposed? Consent agenda is approved. Item 6 is old business. We have no old business, so we'll move into 7. Let's see, the first item there is a 7:10 public hearing. It's 6 minutes from now. Let's see if we can take care of something. Jim? Can you cover that in 4 or 5 minutes? All right, let's do item 7B on the agenda.
So, Mr. Chair, members of the board, in your supplemental packet is the details of this. This is the I&I program with the Buffalo Street televising. Again, this is dealing with their sanitary sewer and addressing the inflow and infiltration that we have. Last year, we did find an area north of Buffalo Street that is shown in the exhibit in your supplement. That covers the Ridgeway area and the Williams Avenue, and also the Buffalo Street. The town board previously authorized us to put together the plans and specs for the televising. We sent those out. We did receive back 2 bids on that. Vision Sewer at $2,425.50, and also HydroClean at $3,007.62. This work will be for televising that area. That will give us the information we'll need for going ahead further with our improvements to do either lining, the manhole work, if we have issues with roots, to find out just what it is that we will be doing for further improvements out there. So this is the next step in our process. This is all part of us performing our $70,000 a year activity. So we would recommend awarding the televising contract to Vision Sewer for the $25.50. That's after you've accepted the quotes that were received, and then also for TKDA to coordinate that work for $595. That is also a not to exceed. All of this will come from the sanitary sewer fund. This work will be done within the next 4 weeks by April 18th, and then we will be back to the town board for putting together the actual improvements when we find out what those will be following the televising of these lines. So we will be going through this step by step with the board for coming up with the improvements and going out for quotes to get that work done.
And then, so we're still on track then to have the work completed this fall yet?
Correct.
Okay.
Any other questions for Jim?
And these are the 2 bids we had, our same outfits we had last year that gave us competitive bids for.
We had, we've kind of have 3 of them that provide to us, and so it's usually combinations of those 3s, if not all 3. With these bids are very close to what we were last year.
Okay. And just to note, these activities have been previously discussed, so there's no changes from anything that we've reviewed with you in the past.
Correct. And this, again, is basically our year 2 of a 4-year plan of doing this work, so we will have more of it coming in the next 2 years also.
That's a good point to bring up. So this meets our 2nd year requirement or obligation to the Met Council.
Correct.
Okay. So there's 2 action items here. One is to receive the quotes, and the second item is to award contracts. Can I have a motion to that effect?
I'll make a motion to receive the quotes from Vision Sewer in the amount of $2,425.50 and HydroClean in the amount of $3,007.62.
Is there a second?
I'll second.
The motion's been made to receive quotes from Vision Sewer and HydroClean. Those in favor of receiving those quotes, please say aye.
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 Aye. Any opposed? That motion passes. And the second action item requested is to award a contract to Vision Sewer and to TKDA.
I'll make a motion to award a contract to Vision Sewer in the amount of $2,425.50 and to TKDA in the amount not to exceed $595 to coordinate the contract work.
Is there a second?
I'll second, noting funding from the sanitary sewer fund.
Yes. Thanks,
All right,
Ed.
motion's been made and seconded to award the contract. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes. And it is now 7:10, so we can go back to item 7A under new business. And that is a public hearing. As I can get back to 7A on the agenda. This is a public hearing. It's a continuation of discussion to amend ordinance number 35. Is there a motion to waive the hearing notice since it's been published?
So moved.
Is there a second?
Second.
Those in favor, please say aye.
Aye.
Aye. Opposed? Is there a motion to continue the public hearing? And this is continuing the public hearing from March 7th. Is there a motion to continue that?
So moved.
Is there a second?
I'll second.
Those in favor, please say aye.
Aye.
Any opposed? Tom, you're going to walk us through this?
I will do that, yes. It's a zoning ordinance amendment initiated by the town board. It's relating to airport safety zoning, and specifically Benson's Airport, located up in the northeast area of the township off of Highway 61. When the airport zoning was adopted, it consisted of safety zoning, which included a primary zone over the runway, 250 feet wide and extending out beyond the end of the runway 200 feet. It consists of a safety zone A, which was 2/3 the length of the runway. Safety zone B, which is another 1/3 the length of the runway. And zone C, which is beyond that area and surrounding the airport a distance of about 10,000 feet. This has been reviewed. I'm showing the eastern side of the runway here. It's relating to a development proposal of this property right here. We've seen a number of proposals on this property over the years, but most recently the town reviewed a 19 townhome subdivision and planned unit development, which included a request to modify the zones of the zoning ordinance to allow additional homes on smaller lots. This was reviewed in 2015, but was denied by the town board. When the town airport safety zoning was adopted in the mid-1980s, the town adopted a model from MnDOT Aviation, and that is the model that currently exists today, as I described, with the 2/3 runway, 1/3 runway, safety zones A, B, and C, and also the primary zone. The primary zone, well, I'll back up. Since the town adopted safety zoning, new models have been put together. The model that was adopted by the town was for a paved public run airport. As we know, Benson's Airport is a private grass strip runway. Since the town adopted the original safety zoning, models have been presented or adopted or suggested by MnDOT Aviation that might be more fitting for an airport of this type. And what I'll give you, the name of it is a special purpose airport zone. Basically reduces the primary zone to 130 feet wide and stops at the end of the runway. So the difference is, instead of a 250-foot wide safety zone, primary zone centered on the runway, with the special purpose airport modeling, it becomes 130 feet wide, and safety zone A begins at the end of the runway instead of 200 feet beyond the end of the runway. So basically it shifts everything back by 200 feet. And again, that's a model that's called a special purpose aviation model. And it's consistent with private airports with grass strip runways. Of course, two ends of the runway. This is the east end again. Shows what the new safety zones would look like under a special purpose public airport. On the west side of the runway, same thing here, 130 feet wide, starts at the end of the runway, veers out that way. When the Planning Commission, this has been under consideration. The town has been sued over the decision not to amend the safety zones as requested. And as a result of that, the town board is reconsidering the zoning ordinance amendments at tonight's public hearing. The Planning Commission reviewed a few options at their February meeting. Specific options they reviewed were to eliminate the safety zones altogether, since they're not required for this type of airport. They also reviewed an amendment adopting the special purpose, or the special purpose safety zoning, again, based on a grass strip model runway. And the final one was just creating a new zone for Safety Zone B, keeping the primary zone intact. Safety Zone A remains 2/3 the length of the runway, but Safety Zone B would be customized, reducing its length from 629 feet, this line right here, reducing it to 425 feet. That shifts the line just a little bit more than 200 feet back to this point right here. So the Planning Commission reviewed the options, and they've made a recommendation to go with this particular proposal here. I will mention again, this is overlaid, showing the development that was reviewed by the town board here late last year. No development is proposed with this. We're only looking at the zoning changes or a zoning ordinance amendment. Currently, the ordinance reads, all land in that portion of the approach zones of a runway as defined in section 7-4.1D of airspace obstruction regulations hereof, which extends outward from safety zone A to a distance equal to 1/3 of the planned length of the runway. So that's the description of safety zone B, 1/3 the length of the runway. Planning Commission reviewed and made a recommended a change to the zoning ordinance that would read as follows. The last sentence would be modified of that section I just read and would be changed to a distance equal to 425 feet from the end of Safety Zone A. So that's not consistent with special purpose zoning, but it's very similar, just not model wording. So this is what was reviewed most recently by the Planning Commission. That is a zoning ordinance amendment that has been recommended for the town board to consider for approval.
Okay, is that it?
That's it.
Ed, Steve, do you have any initial questions to start with?
Nope.
Okay. I see a number of people in the audience, so I assume someone is going to be interested in speaking. Can I ask for a show of hands, how many people would like to make a statement or say something tonight? Okay, okay. All right, well, why don't we start with you, and as you make your statement, please come to the podium, identify yourself and your address.
Okay, I'm Gary McDaniel. I'm an aviator, retired. I live in Centerville, but I have a hangar and an airplane at Benson Airport. I've been there since 2011. I've flown in Africa, I've flown in Alaska, and I've flown over 45 years. And did MDOT, do they have this Amendment B, have they looked at it at all? Where you propose
This particular one, they have not looked at.
They have not, so that's just a private recommendation by who?
That's a staff wording that was put together and recommended for
Okay,
approval by the
so it
planning
doesn't have, you haven't asked MDOT to come in and look at it and say, hey, what do you think?
Not this specific proposal. They have recommended
Yeah.
the special purpose zoning.
My concern is when I fly, besides my passenger safety, I'm concerned about the people on the ground. The current way they have the airport zone provides me, when I take off, I don't try to fly over the houses, I veer off to the open fields. And if you start changing this and reducing that safety zone, I'm not going to feel as safe for my passengers or for the people on the ground. And I'd like you to reconsider and not change the safety zone for this airport unless you have more studies by MDOT or et cetera. Thank you.
Thank you. Who would like to be next?
Mr. Cheetah wants to go last.
Mr. Cheetah wants to go
Daryl
last.
Lemire, 4779 Otter Lake Road. I'm representing Benson Airport. And I think the main thing we want to say is we would prefer to not see any change in this current safety zone. You know, I'm not quite sure if this zoning amendment is the same as zoning amendments I've been involved in my life. But I was a council member in White Bear for a number of years, and we had a issue with a zoning change with the Home Depot Corporation up on the corner of Highway 96 and Centerville Road. And we chose to not change the zoning, and we were sued by Home Depot. We went to the district court, which we won, the appellate court, which we won, and the state Supreme Court, which we won. And our attorney assured us that the courts generally side with local communities on local zoning issues and rarely, if ever, overturn them. I'll just leave it with that. You know, I guess I don't blame people for trying to maximize their property values and money they can make on it. But remember, you're dealing with property from a family who did anything but try to maximize what they received on their property. They minimized it, and that's the Benson family. First of all, they didn't donate, but they sold at a very reasonable cost all the land across the street from the airport, which is now the Ramsey County open space, which if they would have attempted to maximize, they'd have made a whole lot of money, which they chose not to because they cared more about the people of White Bear Township and the people of White Bear and the local area. As John was approaching the end of his life, he knew that that airport had been put there in memory of his brother who was lost in World War II while flying C-47s in the Pacific. Roger died on November 8th of 44, as we all know, and the family named the airport Rogers Field, which we have named our EAA chapter there, the same Rogers Field, in memory of their son. I guess you can't do much more than what John did. He simply donated the property to you and the people of White Bear Township and the local area. Certainly we benefit greatly by flying there. But I just hate to see that really jeopardized, and I hope you understand that these were truly acts that they wanted to. John told me that many times. He likes White Bear Township, and he liked doing things for it. I can't imagine a family that did much more for the township as far as value. That's 66 acres of very high, very, very good ground up there that could have been developed, and it would make a whole lot more money than that little 19-home unit down there. John didn't want that. He wanted people to be able to enjoy his airport. And certainly, there's a few of us, I'm one of them, who is still flying there from when John was alive. And there's one or two others. Everyone else that's there today, John didn't personally know. This airport is about the future. It really is. It's about people who are going to come here, who enjoy it, and just want to be a part of that airport and that community, this community. And I hope you understand that. I'm not trying to minimize what, I understand what they want. My family was developers, so I do understand some of that. Just please consider that when you're voting on this. Let's not jeopardize this wonderful gift of the Benson family. Someone would be quite rich today if you didn't own that property. Not us. I wouldn't get a penny out of it, nor would any of us who fly there. It would just be to some, it would have been to some relative of the Bensons, which there are many. They were multiple generations here in your community, in our community. Thank you.
Okay, thank you. Who would like to be next?
Ron Den, 5655 Portland Avenue. I'm also a member of the Planning Commission. I abstained from this vote, but I was in presence at the meeting. One thing I do want to point out in your comment about the MDOT, what Planning Commission presented forward is almost identical to what current MDOT standards for a grass strip runway is. Only difference is you don't move the primary zone back, which doesn't widen it and actually create an issue on the existing lots on the north development there. That was the purpose behind creating a special. That being said, just so that we know that this is consistent with new model standards, I wasn't at the last meeting because I didn't get the letter of notification, but I did catch on public access Mr. Cheetah's comments, and we had a lot of discussion about this, and I'm curious, and I'd like to know feedback from the attorney about Mr. Cheetah's points about limitations on takings claims. So I would like some clarification from that, from what I saw from the previous town board meeting, if we could get that tonight. If you make a change to the safety zone, there's still, I've brought it up in the past, questions regarding another subsection of the zoning ordinance regarding one structure per 3 acres within safety zone B, whether you can use land outside that. It's something I think you need to be thinking about when you're looking at this, is does that need clarification as well, and how does that affect the overall structure? Being a resident on 5655 Portland, and there's several of us lined up there along Portland Avenue, this is a dramatic change from what we have expected there to be, because this safety zone was in place. I knew that planes had an area that they could ditch the aircraft. I knew that there's some place for them to go. Supervisor Pruthorn brought up that last time he flew, and he said it's kind of daunting as you're coming up across there. So there is some relevant behind the safety zone as it was, and for safeties of those of us on Portland Avenue, flyers out of Benson Airport. So I think I'd like clarification on the limitations of the taking claim and what's really in the best interest of the township as a whole, not just fear of litigation or anything like that. So please take all those matters into heart.
Okay.
Thank you.
Thank you, Ron. And the town attorney has been looking at the takings issue, and he'll, as I understand, you'll be making some comments later, right, Chad?
Yes.
Okay. Anybody else like to make a statement?
Al Cheat on behalf of the airport. I've spoken today to Mr. Short, and I thank him for his time. I've spoken today to Mr. Lemons. I thank him for his time. I called your lead attorney. He's on vacation for a week. I spoke to the number 2 guy that is defending you, Jason. He sent me a couple of very helpful cases. A couple of things that he pointed out, the statute of limitations trigger that I relied on so much. My argument was that it was 4 years. In fact, it's 6, but the Stoddards are still nowhere near 6 years. The ordinance passed in 1985. The Stoddards bought in 1990. They've been there 26 years now. I think it's kind of late. The case law that the number 2 attorney pointed to says that you have to have a final determination before you trigger the statute of limitations. That could be an issue. The more fundamental issue was there a taking? And even the Stoddards can't deny, and their lawsuit explicitly recites at page 6 that you made findings when you denied them at the October 5th meeting, that the property has knowingly been purchased by the applicants, the Stoddards, with the safety zones in place.
Secondly, state law allows a government body to adopt airport zoning ordinances that are more restrictive than the minimum standards imposed by the state. I think Supervisor Prudhoe had asked about that. Didn't MnDOT testify that you don't need any kind of a safety zone? That's true. And at the same time, state law very clearly gives you the discretion to put in place a more restrictive than necessary ordinance. I think there's been some twisting. MnDOT has not said that the airport is just as safe without the safety zone or with it shrunk. That's just not the case. Nobody has said that. It flies in the face of common sense. I won't berate it, but if anybody has any questions, I would try to answer. But I would, from the top, tick away, I don't believe that there was a taking. You have a discretionary call that says that you can regulate. And if the law in White Bear Township becomes that if we don't like your ruling, we'll just sue because that must have been a taking, well, that's not the law in Minnesota or in the US, and it's probably not a good policy for you. One of the things that the key case of the US Supreme Court, not just the Minnesota Supreme Court, says is that in looking at a taking case, you have to determine whether the regulatory action interferes with reasonable investment-backed expectations. When you move in and buy property in a safety zone that's not buildable, what are your reasonable investment-backed expectations? Well, if we don't like it, we'll just sue and they've got to vacate. That's not reasonable, and that's not the law. I spoke to Mr. Short today about the case a little bit. I got some input from the number 2 attorney that's defending you folks, and he said there has been no scheduling order issued. And this is something that we have to do in practice now. They have kind of fine-tuned scheduling orders. It is what it sounds like. This is what you're going to do, and this is when you're going to do it. That has not been issued in this case. The case has not been set for trial. And the lawyer that's representing you emphatically says the judge has not said that you lose. I was told that today, and that is not the case according to your defense counsel. I would urge that you not be in a great big hurry to vacate the safety zone. I'd urge that you really not be in a hurry to do it because it's a discretionary call until and unless you've got the whole thing settled. Because the case is not going away if you simply throw down your shield. The Stoddards need 3 things, and Mr. Short can correct me, but I think to build, they're going to need the safety zone vacated because right now nothing can go there. I think that to build, they're going to need a rezoning or a zoning variance. I think that's a matter of semantics. That's a discretionary call for you, both of those things. And thirdly, they're going to need a PUD. You have an absolute defense with the safety zone in place. If you throw that defense away without something back from the Stoddards, there's no good reason. You're not protecting the airport, which I represent, but more importantly, you're not protecting your citizens. This thing will wait. See what the Stoddards would do as a quid pro quo if you vacate the safety zone. With that, I appreciate your time and attention. Does anybody have a specific question for me? Thank you much.
Thank you. All right, if there are no further questions or comments, I'll give you, oops. Well, go ahead. Scott, let me take her first.
Tanya Prey at 5675 Portland, so up near where B and C are. If the zone is planned and changed, obviously that allows more housing closer to the end of safety zone A. So based on information heard this evening, with the yards along Portland that are larger, no residents in the yard, and if they need to dump a plane, not knowing much about aviation, but that would seem the likely place to do that, giving less room and impeding on the safety of those houses. I would just like that to be a consideration.
Okay, thank you. Okay, Scott?
Scott Stoddard. I'm the owner of the property in question. The only thing I have to say is it's been years and years that people have been saying we knew about this safety zone when we bought the property. I'm just simply here to tell you, we didn't. I have no idea how we would have known at the time, so we did our due diligence as far as going to the county and things like that. I should probably just leave it at that since we are in litigation. It's just one of the things that has been constantly said about us. You know, we've never been in a position to answer that, so here I am, I'm going to answer that. Thank you.
Thank you. All right, if there's no further comments or questions, statements,
Make just one.
we have to have you come to the podium.
One final comment. As we all know, ignorance of the law is not a defense. We're all charged with knowledge, with notice of each and every ordinance that you've got. And to say that nobody specifically told us simply doesn't work. Everyone takes subject to zoning ordinances. And whether or not the Stoddards want to admit that, unfortunately, perhaps for them, that is the law. They had notice as a matter of law about the zoning and about the safety zone. It's a matter of public record. You can't ignore it and say we didn't know. Thank you.
All right, one last chance. Going, gone. I'll ask for a motion to close the public portion of the hearing.
So moved.
Is there a second?
Second.
Motion is made and seconded to close the public portion. Those in favor, please say aye.
Aye.
Any opposed? All right. Tom, let me just ask you one quick question just to lead off here. If we do not modify the safety zone, that does not preclude any construction in safety zone B, is that correct?
That's correct. The property.
It's just a lower density of construction.
Safety Zone B requires lot sizes larger than our 3 units per 1 acre. Safety Zone B requires 1 unit or allows up to 1 unit per 3 acres, so 3-acre lots. So it's still a developable property, just not at the density that
Okay.
maximizes the property.
Okay.
Tom, you ran a couple of numbers when you did that. Do you know approximately how many units they could have in there and abiding by the zone?
Divided up in 3-acre lots, they could probably get 5 lots. If they did twin homes, that would be 10 units.
10 units, okay. So instead of the 19, they'd be down to 10.
Correct.
Chad, you were doing some research for us on a couple of these issues. Did you want to comment on them? The statute of limitations, for example, and I'm interested to hear your comments on the trial schedule.
Sure, Mr. Chair. Yeah, I think that's correct. Mr. Chair is correct. There's no scheduling order issued yet. That should be issued, I would assume, in the next 30 to 60 days, at which point in time. But all that does is simply schedule when discovery occurs, when pretrial would occur, and when motions have to be heard by, and when the potential trial would be. And I would estimate the trial wouldn't be until probably early next year, if it goes that far.
Okay.
As to the issue of, I understand, because there's ongoing litigation, I'm constrained as what I can tell you, what I can comment on. However, in terms of the issue of statute of limitations, it is 6 years, and that 6-year period would have commenced when the town board denied the PUD back in October. So that's with the start of the 6-year period. So it's 6 years from that date.
So in other words, they still have over 5.5 years to pursue.
Yes, that's correct.
Okay.
That's my opinion. And understand, so it's not based on when the ordinance was passed, it was based on when the denial occurred.
Okay. All right. Let me ask you, other board members, Ed, Steve, any questions or comments?
No.
Can I ask Mr. Levens a question?
Are you willing to take it?
We'll see.
Well, even though we still have to have you come to
I
the...
want to go to the microphone.
Unfortunately, Mr. Lemons and I are old friends who've tried cases against each other. So I've gotten to argue with him and his clients, but I've never got to cross-examine them. But this isn't a cross-examination.
Mr. Cheat, am I going to have to use this?
You look good in the black robe. Question is, there's a threshold question. Regardless of which statute of limitation applies, whether it's 4, which I mistakenly said, or 6, which is correct, the threshold question is there a taking? Just because there's an ordinance, I think Mr. Lemons will agree, doesn't necessarily mean you've got a taking. And I'll let him comment on that. The other thing that triggers the taking and the burning of the, I call it the fuse, and that is the statute of limitations is a fuse. And once that fuse burns, it's too late to sue. And the case law that I got today from your attorneys that are representing you, that I've read, I've been reading it a bit, says there's 2 ways to light the fuse. One of the ways is to have a final determination, which you had in October of this last year, so you're right. We've got 5.5 years thereabouts before the fuse burns out. But the other way for the fuse to go out is if the applicant, namely the Stoddards in this case, have been repeatedly told no. In my conversations, no, you can't develop there. My conversations with Mr. Short today lead me to believe that there's a 10-year period of minutes going back where the Stoddards' plans have been turned down. And there was a plan that was offered in 2006 that we're aware of that was turned down by the Stoddards. We don't have the quote-unquote final determination until your October 5th, 2015 determination. But we can light the statute of limitations fuse, that is the time within which you have to burn or sue, and if the fuse is burned out, you can't sue as a matter of law. I would respectfully suggest to you that 3 things. There is no taking, regardless of whether or not it's 6 years, 4 years, or did it happen in 1985. I don't think there's been a taking as a threshold matter, given your inherent right to regulate. Second of all, I believe that you've got more than adequate documentation to show that you denied the Stoddards what they requested more than 6 years ago. Third of all, there's another matter, and lawyers aren't supposed to ask questions that they don't know the answer to, but I don't. The Stoddards, says the Minnesota Supreme Court, must pursue all administrative remedies, and I'm wondering if there is an appeal from your October decision, which they should have filed with you. Don't know if that's required or not, but the Minnesota Supreme Court says the matter is not ripe until they've exhausted all administrative review. It's tough for me to believe that there wasn't an appeal that they couldn't have filed. But anyway, I would invite Mr. Lemons to correct me if I'm wrong. Statute of limitation issue, that is one issue, but it begs the question, the threshold question, was there a taking, regardless of the age of this thing? And secondly, again, I'll just say that I believe you turned down the Stoddards multiple times, well over 6 years ago. Third, you certainly turned them down back in 2006, and last I checked, that's 10 years ago, more than 6 years. I thank you for the unprecedented opportunity to talk. And thank you much.
Thank you. Well, I think I understand the town attorney's position and interpretation of the statutes and the laws, but Chad, I'll ask if you have a response that you'd like to make that you think would help us out.
Again, because there's ongoing litigation, I'm really constrained as to what to say. When the statute of limitations run, there could be a question there. I'm not going to deny that. I do think, though, that it would probably commenced last October. But there's a possibility it could have run earlier than that. There's always a possibility. But again, just so everyone understands, there's There is special counsel that's been retained to represent the township in this matter. And while our firm does assist that special counsel, nonetheless, we aren't the main attorney. So I don't want to undercut their position on by what I say, so I'm somewhat limited on that basis. One comment I would make about zoning, it's true that it's a regulation and that the town does have the right to adopt regulations involving land use. However, there are occasions when regulations can spill over into a taking, and that's what the town board has to be concerned with, because if a taking is found to exist, it can get to be quite expensive for the town, and that is an issue that really the town board needs to be concerned about, has to be sensitive to, and let them know it is. So at this point, that's really all I can really say on this matter.
How about administrative remedies?
Oh, yes, Mr. Short reminded of administrative remedies. There was an offer to the Stoddards to appeal the decision last October. They elected not to take it.
Mr. Chair, I'd like to comment on Al's third point regarding the, what he referred to as the town board turning down the Stoddards. The town board has certainly had a lot of contact with the Stoddards. But in 2005, the town board approved the plan submitted by Classic Custom Homes. We didn't deny it, or you didn't deny it. And since then, while there's been ongoing complaints, criticisms by the property owner, the town board simply listened and was not in a position to deny it. It was just, we had several developers contact us, but there were never any denials. Unfortunately, it's been the course of the relationship between the property owners and the town that might lead you to believe that they keep submitting plans that the town keeps turning down. We've been waiting for an official plan for 10 years, finally got one in October. And so it's important that those of you here tonight understand when Al believes that the town board has been turning him down for 10 years, it hasn't. We've been waiting for 10 years for a plan, something official submittal.
Right. And the point Bill makes is important because it requires a formal rejection, not an informal rejection of plans that will you approve this or not. It has to be a formal rejection. And the only formal rejection I'm aware of is the one that occurred in October.
That's correct.
So can I interpret this in my language, to just make sure I understand? I'll refer to what Bill mentioned, that we've been looking at plans and sketches for years on this piece of property. And as a matter of fact, in 2005, I think the plan that they submitted to us, we didn't reject it, but then the Stoddards took that plan back, as I understand it, or one of the plans they took back.
That's true.
And so all we're looking at up till October of 2015 had been plans and proposals, concepts to develop that piece of property. The first formal action the board took to respond to a formal request for permits, whether it's for a PUD or subdivision, et cetera, that application, that first time that kind of a formal application occurred was last October in the form of submitted permit requests.
In fact, Mr. Chair, you make a good point. It's the formal application by the landowner that triggers it, denial of the formal application. Since
Okay.
the October was the first formal application, other than informal inquiries, that's the one that we have to work off of.
All right, thank you.
And I would make one other point. Just so we're clear, again, while I am constrained, the town board is not backing away from this, neither the attorneys representing the town. But we are realistic, and we have to advise the board as to what could happen and what the results are.
Okay, thank you. Just a couple of comments. First of all, tonight we're dealing with and will address one proposed action, and that's to modify or amend the safety zone ordinance. That's the only action item we're looking at tonight. Tom mentioned, describe the possible options or alternatives to the existing safety zone ordinance. One thing that benefits the township is that since 1984, the state has modified and updated their guidelines for safety zone dimensions. And what Tom is identifying is a safety zone designed for a grass strip airport that the state, that is based on a state design. One thing that has changed over the years, as I understand it, is that what the state is telling us now, this is their proposed or suggested design, but it's not a requirement
For this airport.
for this airport. So MnDOT is not regulating us, but it's suggesting to us a design or designs that could be used for whatever the appropriate airport is. In this case, they have a design for a grass strip, so that's what one of these options is based on. As far as making a decision, the town board, and I thank the town attorney for clarifying, the town board is not refusing to address the issue, but the town board also recognizes that it's representing at least three parties here. We have the property owner, and any of us have rights as property owners within the township, but we also have to address rights and responsibilities towards those neighbors in that area and in other areas. And finally, we have to address our responsibility to the township as a whole. And one of the issues that we're concerned with is that if we are risking major or large liabilities to the township, we have to be careful that we're responsible in how we deal with that. It's far beyond just saying, well, let them take us to court. Ultimate impacts to the township could amount to could easily amount to tens of thousands of dollars. In worst case scenario is liabilities to the township in the hundreds of thousands of dollars, several $100,000. That's not to say that that's the outcome. That's not to say that that's what's going to happen, but we have to consider those risks. What if? And White Bear Township certainly has benefited, now I'll close after this, but I'll say that White Bear Township has certainly benefited from the contributions from John Benson and his estate. I think the airport is an asset to the township. And it's a much bigger asset than it is a risk, in my opinion. And the township certainly wants to continue working to continue a rewarding relationship with the Benson Airport. So with that, I'll ask for any other comments from the board.
Do you have to close the open portion of this meeting?
Yeah, we did.
We did already? Okay. Nope.
So we have, how many options did we wind up with, Tom? 3? We have 3 options, 1, do nothing. We have an option to pursue an amendment to the existing ordinance to shorten the safety zone B, and another option is to use the state guidelines for a grass strip to set the dimensions of the safety zone.
Those are 3 options, and a 4th option could be to eliminate the safety zones entirely.
Altogether, okay. So I'll have to ask the board what their feelings are. Is there a response to support any one of those options?
My comment is, I think you made a very good point, Mr. Chair. The aspect of this goes well beyond just those neighbors around there. This is a township issue as a whole. While I understand the concerns, I do remember back when this matter was brought before the board before, and the gentleman from MnDOT was here, as a general caveat statement, he said that all pilots would like to have nothing but huge safety zones, and that most pilots existing there may not even know what the safety zones are as they existed today. And did say that there is no need for them. You can have them, you don't have to have them. So from that standpoint, looking at it from a whole and looking at the property owner, I'm comfortable making decision tonight to go, you want to tell me what I'm interested in? I'll make my statement.
All right.
Excuse me? I did not finish, we didn't vote on any yet, so. I said I am willing to make a statement, or pick one of these options.
Do you have a preference? Which
I
one?
do. I'll go with the recommendations for the grass strip zone as outlined by the aviation recommendations.
That's option 3 in the packet?
Option 3.
Option 3 in your supplemental packet.
Are you making that in the form of a motion?
I'll make that motion.
I'll ask for a second. I'll second that motion. Any other comments from the board? I'll call the question. Those in favor of selecting option 3 to amend the land use safety zone at Benson Airport. And let me just clarify and confirm here, Tom, this safety zone applies to both ends of the runway, right?
Correct.
Okay. Motion is made to use the guidelines in option 3, and that's based on dimensions for a grass strip runway. Those in favor of, to set the safety zone dimensions. Those in favor of the motion, please say aye. Aye. Any opposed?
Nay.
The motion passes.
And I guess I would just like to say, I'd like to thank Tom and staff for working this and giving us some options. The attorney's gone through this, I think, pretty thoroughly. We respect the planning commission and the attorney's, recommendations quite highly. It's just, I struggle with that. I know we may incur some financial loss, but I don't want to see town residents paying their tax money for lawsuits, courts, attorney's fees. But I gotta believe that a reasonable judge or jury would find on the township side. I think they would help us preserve that safety zone. I think they would basically want to see us protect the residents, the pilots, and their passengers. So I go back to this taking, this has always been platted to be developed. The road was figured that way. It's just the Stoddards want to do more than what we allow. They could get 9, they want 19. That's just something they're going to have to try to deal with, at least in my opinion. They, I pretty much stand by my original findings of facts from the October meeting. I listed 10 of them. I'm not going to read them out again, but that's mainly my objection to doing anything with the safety zone.
Thanks, Ed. Ed, I'll give you a chance for a rebuttal if you'd like.
The other Ed? No.
Otherwise, we'll move on to the next item on the agenda, and that's item 7B regarding a seepage pond at well number 5. And that's town engineer. Jim, that's yours?
Yes. The attachment is shown with the exhibit. So we have our water treatment plant just off the roadway, and then to the west behind it, we have the seepage pond. That is the backflow discharge that we have from the process of the facility. We had the MPCA, the Minnesota Pollution Control Agency, out, which performed a site inspection last fall. The pond was not functioning appropriately. We had a survey and we had borings taken of that pond in the back. We have received that information. We have found that there has been sediment buildup over time, and that both the bottom and sides are not infiltrating at a rate that was used through the original layout. So at this point, we will be performing removal of material and improvement to that infiltration of the pond. So tonight, we are requesting to prepare the plans and specifications and go out for bid for those improvements to bring that ponding area back into its design criteria. That would be in an amount not to exceed $2,350. We will bring those construction bids back to the town board once we have received those.
Just one quick question, Jim. You know, we have substantial work going on right now to rehabilitate that well 5 facility. This isn't going to impact any of that work or delay any
No.
schedule to restart that.
All of the previous work that we have with the facility is inside, and we actually are getting to the end of that activity, and all this will be done separately behind that building.
And when is this proposed, if we go forward, when will you be able to do this work? When will this be done?
The spring.
The spring yet?
Yep.
Any other questions?
Nope.
Okay, so the request is to authorize TKD to prepare the plans and specs and advertise for bids.
Correct.
Is there a motion to that effect?
So moved.
Is there a second?
Second.
Okay, the motion's been made to authorize TKDA to prepare plans and specs and advertise for bids for pond improvements at well 5, and the expense not to exceed $2,350. Okay, I'll call the question. Those in favor, please say aye.
Aye.
Any opposed? That motion passes. 7D on the agenda is regards lift station number 3. Jim, that's yours?
Yes. Mr. Chair, members of the board, with our Lift Station 3 improvements project that the town board has already authorized, going through that activity of making the improvements to that area, to that lift station, we have found that the township currently does not either own property or have an easement for that facility. We have been working with the attorney and town staff on obtaining and did all of our search for that documentation, and we have come up with none existing at this point. So
are we squatters? Never mind.
One way of
Sorry.
looking at it, but not really.
All right. Well, I kind of figured we know the answer, but I just wanted to get that off the table.
Oh, yeah, great.
So
Okay,
Ramsey
that's-
County is the
that's
owner
off.
of this?
Yeah.
So, I mean, what we're asking tonight is to work with the attorney to determine just what we need to obtain and get the legal rights to that. Not only is the lift station work that we are going to perform in question, it is also the sanitary line, the gravity lines coming to it, and the force main that leaves it. So all that will be looked at.
So basically, we're talking about authorizing a records research.
And put together the necessary ownership documents that will be bringing back
Okay.
to the town board.
So there's no easement lines anywhere for this property?
Well,
Or
there's no easement for the lift station. We do have we have to double check once we know everything's located, we'll have to go back and double check for everything else as well. But we know there's nothing for the lift station itself.
Really?
I think
happens.
the project was built in the early 1970s.
71.
And as Jim said, the documentation their research. I think it's the first time since I've been here we've actually asked someone to dig back and look for the documents. We couldn't find them, so we're asking the town board to authorize the attorney to find them.
Any other questions? Is there a motion?
Motion made based on staff review and recommendations, direct the town attorney and engineer staff to prepare and obtain ownership documentation for lift station number 3, as well as the connecting sanitary sewer pipes, manholes, and force main.
Is there a second?
I'll second.
Motion's made and seconded. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes. Item 7E on the agenda is 2016 Seal Coat Project. Dale, this is yours.
Hey, good evening, Chairman Kermes and Supervisor Prudon and Supervisor Rusick. Yes, that is mine. We opened bids on March 10th at 9 a.m. for the 2016 Seal Coat Project. It had been advertised in the White Bear Press on February 10th and 17th prior to the bid opening. We received 4 bids. One from Allied Blacktopping Company, one from Aztec Incorporated, another from Pearson Brothers, and Farner Asphalt Sealers. Since the bid opening, I've had a request by Aztec Incorporated to withdraw their bid. They had made a mistake in their, not in the total bid, but in their unit pricing, and they used last year's unit pricing and last year's quantities. So when I reviewed the bid the bid documents, I discovered that, called the contractor, and they requested to withdraw, and I'm recommending we reject the bid also. So the low bid was from Allied Blacktopping for $93,478.28, and I'm recommending that we award the bid to Allied Blacktopping Company for the 2016 Seal Coat project.
Okay, and the $93,478 is in the 2016 budget.
Correct. My estimate was 95,000. We have 110,000 budgeted for Seal Coat.
Okay, any questions for Dale?
You want 2 motions on this?
Yeah, you want to see 2 separate
Yes.
motions? Okay.
All right, based on Public Works Director review and recommendations, I'll move to reject Aztec Corporation's bid based upon their withdrawal request.
Is there a second?
Second.
Those in favor, please say aye.
Aye.
Any opposed?
And then I would also move to award the 2016 Seal Coat contract to the low bidder, Allied Blacktop Company, in the amount of $93,478.28. This is funding coming from the Improvement Fund 505.
Is there a second?
Second.
Motion's made and seconded to award the Seal Coat contract to Allied Blacktop Company. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes. Item 7F on the agenda is street sweeping services.
Yes, and that's me also, Chairman Kermes, Supervisor Prudon and Rusick. Say I went, the 2016 stormwater budget has included contractual street sweeping. Typically, the town has used staff, and it can take up to 3 weeks, or normally it's 3 weeks of sweeping, and involves 2 staff. I've been pursuing this and put it in the budget this year for contractual sweeping. They would be done in a contractor coming in with 4 sweepers, minimum 2, but 4. They've be done in anywhere from 2 to 3 days with the entire town, which is timely. It does, for water quality purposes, it's plus, and then we would end up having the debris hauled in dumpsters as we have when the public works staff has performed it. I got 2 quotes for hourly rate for sweeping, one from Allied Blacktop Company, another from Pearson Brothers Incorporated, for an per hour price. Allied Blacktop was $80 per hour, and then Pearson Brothers were $83 per hour, and that includes the machine, operator, fuel, all that. Estimating that the spring sweeping program estimated is at about $7,200 for the sweeper for 3 days. And what I'm recommending to the board is consider approval for the proposal from Allied Blacktopping for $80 per hour for sweeping the spring.
Dale, would they do this work in 2 to 3 consecutive days?
Correct.
They'll start on a Monday and be done by Wednesday.
Yeah.
The entire township.
And at this time, they're looking at mid-April
Mid-April?
to start.
Okay. And the $7,200, is that, are you looking at it as a not-to-exceed amount?
That's an estimate on my part, based on 3 days for sweepers. So it could be slightly more, but I'm pretty confident that estimate is close.
Okay.
So you could use that, you could use it as a not-to-exceed amount, yes.
Okay. Ed, what questions?
I have a question, insurance?
Yes.
Is there hold harmless agreements that
They'll have
are a
to-
contract that the attorneys will look at before we agree to this?
I can prepare a contract and I'll ask for the insurance
I
certificate.
would agree to this, provided we protect the township.
All right.
I'll make a
contingent on
motion,
that?
I'll make a motion, based on Public Work Director review and recommendation, approve the proposal for street sweeper services from Allied Blacktopping Company for $80 an hour per sweeper for a minimum of 2 sweepers with, with funding from the Stormwater Operating Fund, with the caveat that contract is prepared and reviewed by our township attorneys.
Okay, is there a second?
Just a quick question first. Pearson Brothers shows city to provide truck disposal sweeping and provide the water truck. The
Thank you
same
for-
with Allied?
Thank you for pointing that out, and that's the same for Allied. The town is going to provide the dump truck operators and water for the sweeper, yes.
I'll second the motion.
Motion's made and seconded to, motion's been made and seconded to award the contract for street sweeping services to Allied Blacktopping Company. Those in favor, please say aye. Aye. Any opposed? That motion passes. Item 7G on the agenda is well number 2A rehabilitation.
Yes, we've, historically, in the past few years, we've rehabbed typically one well a year. It's based on the actual pumping hours for the well and then also the age of the well. We've, this year it happens to be well 2A, and the work, rehabilitation work includes removal, inspection, replacement of parts, if needed, and approved by Public Works Director, of the well motor, column piping, pump shaft, well pump, and related items. The 2016 well 2A is being recommended for the rehab, based on that pumping records. It was last rehabbed in 2009. Staff has recommended approval of the specifications. The town engineer has reviewed the specifications. I do have some edits that he's recommended I do, and I will correct those before sending out the specification for bid.
Okay.
And
Town engineer satisfied then.
correct. And there's, I've got 30,000 estimated. It should come under that amount, the rehabilitation work, and it will be funded by the Water Operating Fund.
Okay. And this is all consistent with our existing CIP and this year's budget. And well number 2 is that serves the south section of the township, and it's the larger of the 2 wells?
Yes.
Okay. Okay, any other questions for Dale?
Nope.
Just one, Chad, have you seen this? Is there an issue with the way this is spelled out?
Chad has not had reviewed it.
I just saw it this afternoon, so I'll review it.
Okay. Well, I was just curious, because it seems pretty detailed for a bid specs. It's like,
Well, I'm trying to cover, there's a lot of things to cover, so I'm improving the specifications all the time, because there's added things, for instance, qualified contractor, ability to make sure they pay their subcontractors. Tons of detail that needs to be incorporated.
And you're saying the town engineer has gone through this?
Yep, so I have reviewed it and made some comments, and Dale will add those into it.
I mean, because I know it's not a formal contract, but it is a bid sheet. It's pretty specific.
They're just getting better. Continuous improvement.
And so when Bill gets them next time, he'll have all the answers.
Bill,
It's
doesn't
never going to happen, I know.
Okay. Any other questions?
All right, I'll move based on Public Works review and recommendations, that we approve the plans and specifications for well number 2A rehabilitation with funding from the Water Operating Fund.
You want to do this in two motions?
Yeah,
All right, is there a second?
Second.
Motion's made and seconded to approve plans and specs. Those in favor, please say aye.
Aye.
Any opposed? That motion passes.
And also move to authorize the advertisement for bids for well number 2A rehabilitation and set the bid opening date Thursday, April 14th, 2016 at 2 PM at the Public Works Department office.
Is there a second?
Second.
Motion's made and seconded to advertise for bids for well 2A rehabilitation. Those in favor, please say aye.
Aye.
Any opposed? That motion passes. Next item on the agenda is 7H, and that regards a Columbia Park water project. Tom, this is yours.
I'll start this off, and I'm going to introduce Brian Corcoran. He's staff representative for the Vadnais Lake Area Water Management Organization. They put together some grant funding and for a project to help clean water in Lambert Creek, near, in fact, in part of Columbia Park. Brian could probably speak to specifics on the project, and I've got several photos here. I can put them up if you want to give the details on the project. This is something that was reviewed by our park board because it's proposed in Columbia Park, and they've support the project, so they're recommending that the board adopt or move forward with what Brian's going to propose here.
Okay.
Good evening. Thank you for the time. As Tom said, we're looking for your approval to
Well, Brian, we have TV audience watching you, so could you just introduce yourself and tell them where you're from?
Yep. Again, my name is Brian Corcoran. I'm from the Vadnais Lake Area Water Management Organization. I'm the water resource manager for the watershed.
Thank you.
We are here, as Tom mentioned, to ask for approval for the use of the southern end of Columbia Park for a treatment wetland system. The Vadnais Lake VLAMO, I'll make it short, VLAMO last fall put together an application for grant funds through the LCCMR, or the Legislative Citizens Commission on Minnesota Resources, for a project to address an E. coli impairment along with nutrient impairment at Whitaker Pond, or the headwaters of Lambert Creek, where you see on the right-hand side of this picture up here. We've been working with a consultant for about the last 2.5 years to identify where E. coli is coming and the impairment in this creek. This project came about from that research. We had an opportunity, as I said, to apply for these grant funds, which we did. The process went through the LCCMR committee. We have moved into the funds being recommended to the legislature during this March session. If those funds come through, we would be able to move forward on this project. That being said, the first hurdle would be getting the okay from the township to use this portion of Columbia Park for the treatment system. The second hurdle would be getting bids from our contractors that would match the funds that we would be receiving for this grant. It's a $500,000 grant. That's what we applied for. This treatment system is both a in-the-ground BMP to address water quality, along with a research project. So the University of Minnesota would be on board for this project as well. They would do their own test and research on pathogens and how effective this system would be to remove pathogens. We, along with our consultant for the project, would use it to address how well it removes E. coli and other nutrient impairments in the Lambert Creek system. The bottom picture here is a rough diagram of what the wetland looks like. It's roughly 4 feet deep. It's an upflow system. Water goes in through the bottom. It's pumped up through different sorption medias. Those different medias will hopefully address E. coli or phosphorus or PAHs or whatever we're trying to tackle. It's going to be a 3-cell system. One of the wetlands is going to be a control. And then the two other wetlands will have the different absorption medias and native plants growing on the top. There should be a picture there, Tom, of what these look like. This is an example of what the wetland system would look like once it's in the ground. The white pipes sticking out of the ground are monitoring ports. Those could be cut lower and capped, and depending on how the plans come out for this project, that would be figured out at that time. You're able to walk on these wetlands. You can mow them if you need to. There'd be no hazard to the public with these wetlands. The water that goes through it would be infiltrated into the ground. Because it's up on the hill at Columbia Park, it'd be gravity fed from the pond into a cistern. I think that was shown on the previous one. And then a solar pump would pump it up to the treatment system. At this point, we're asking for the okay to use the property for this project. That being said, there are many hurdles moving forward to get this project into the ground, one being approval of funds from the legislature, two, where the bids come in from the contractors.
So, clarify for me, where does it discharge to?
This is can I come over there?
Oh, sure.
Is that all right? This is an overview schematic of it. So the water, we would either be pulling it out of the main Whitaker Pond here or the forebay. It'd be gravity fed into the pump vault, and then a solar pump would pump it up into these wetlands. It's an upflow wetland system. Once it gets to the top, the water would drain out into an infiltration basin next to the wetland. So there's 3 wetlands, 130 feet by 10 feet. At the end of each of those wetlands would be an infiltration basin for the water to infiltrate back into the groundwater system after it's gone through the wetland treatment
The
system.
ultimate outflow goes to groundwater.
Yep, and then they would have an overflow in case for some reason something backed up, and that overflow would go back into the pond itself.
All right, now,
at this
you
point.
keep referring to the system as wetland, but now you were saying you can walk on it, so it's a dry surface, it can be used.
Yep, you can walk on it. The idea, we would have signage up there. If this project goes through, there would be walking paths through there for folks visiting the park to see what exactly is going on at this site. That's per grant requirement.
So it's not classified as a wetland?
No, well,
Okay.
it's a, no.
Now, are you looking at this as a permanent facility, or is this going to be temporary?
As of now, the grant goes through 2020, so we would have roughly 3 years of research on this project, and then all the paperwork, reports, and everything done by the end of 2020. That's the life of this grant from the LCCMR. That being said, depending on how well it works, Vlamo would like to continue testing its effectiveness. The absorption medias in these wetlands can last up to 25 years. That being said, if it needs to be removed, I would think Vlamo would put that in to paperwork when the time comes.
Okay, so at end of life, that's where my next
Yep,
question,
yep.
final question would be is, who's responsible for reclamation then if you decide to shut it down? So Vlamo would reclaim the site?
Vlamo would have to be responsible for
All
it.
right,
There's
okay.
no responsibility to the township other than letting us use this and also easement or whatever type of contractor paperwork we would use moving forward. I know I've sent Tom some rough drafts of paperwork at this point. Before we move forward on that, we wanted to come and present this to you folks and also see if there's a possibility of moving forward with the use of this and then the paperwork.
Brian, we've talked before at some of the Belamo meetings, if this works, there was some discussion of expanding it. Is there room at that site to expand it if they feel the need?
If we feel the need and it's all right, the idea is, and the point of these 3 treatment wetlands is to figure out exactly what absorption medias, what combination of plants work best at dealing with E. coli or phosphorus or PAHs in storm ponds, and to use that information to make a small-scale wetland treatment system for specific storm ponds or beach issues throughout the metro and the state. So the idea is for this, it's treating water now, but it's been downsized from our original application.
I believe, didn't you originally ask for $1 million to make
Yep.
it about twice as big?
Yep.
Yeah.
So it's now turned into more of a research project, but there
Research site.
still is a water quality benefit, just not what we had originally proposed.
Have you generated or estimated any volumes that would be infiltrated to the aquifer?
We
So
have
many
not.
gallons per year? Or-
And we can't until we get the geotechnical data back from the soils and what's going on out there. It may come to the point when that's been done that this might not be possible at this site. We just don't know that information at this point. It's just the way this grant process is.
But that could be a data point then, the amount of flow through into the
Yep.
aquifer.
Yep.
Okay. All right.
And then there was one other graph here. This would be the footprint, this red box here would be the footprint of what it would look like at Columbia Park, this specific treatment system. So that's 130 feet roughly by 30. And that would be the estimated location of where this project would go if we get the funds and move forward on it.
Couple of comments, if I could, please. This part of Columbia Park is upland area, slopes down into a wetland right in here. This is an older aerial photo. This shelter is no longer there. It was demoed several years ago. These are older pieces of playground equipment that have been replaced, and the playground has been shifted. This is the soccer field area. This is the only part of the park that's actually programmed. This is just passive recreation area. It is upland. It's for use by anyone, but there's no specific structures in that area right now.
Steve, did the park board have any issues? Or?
No, actually, I think they had quite a bit of discussion with you, and they were well on board with this. I think it's a good use and good practice for our community.
Okay, okay. Anything else, Tom?
Nope.
So the request.
Recommendation from the park board is to support the use of this portion of Columbia Park for the project. And
At this point, it might be appropriate to refer to it as concept approval, and there'd be several steps involved before anything could actually be built. Chad mentioned to me that the town would normally process this through a license agreement, and the terms in the agreement would be established by the town. It could include final design approval by the town before it's actually, they proceed with construction of the project, and have provisions in there for restoring the site once the operation ceased up, whenever that is. Other conditions like that could all be included in a license agreement. If the town board is inclined to give concept approval, tonight would be a good time to authorize the town attorney to work with staff and Velamo to compose that agreement.
Brian, you feel that that's enough for you guys to keep moving through on the bottom
It
line?
is, and thank you, Bill, for that. Until we know, we're trying to do this and not put too much work for no good. We're trying to go along with this whole process as the grant moves along. So we'll find out for sure at the end of this legislative session, the beginning of June, whether we've gotten the funds. We will go out for bid for a contractor prior to that. I think that is perfect, and I think we can move forward with what Bill has proposed.
Okay. So we're looking for two action items, and one is to support the recommendation, and then the second one would be to authorize the town attorney to draft up an agreement.
If they're successful in gaining the funding.
I wish I could have came and said we have the funding, but it's
Yeah.
just, we want to make sure we can accept the funding if we get it and are
Sure.
on board with the township. So if
Chicken
we're
and the
working
egg type of
backwards on this,
exercise.
I apologize for
Okay.
the confusion, but
Okay.
fortunately, that's how it works.
Any other questions from the board? If not, is there an action?
So, the first one is to recommend a grant concept approval of this plan. I'll make a motion for that.
Is there a second?
I'll second it.
Motion's made and seconded to approve the proposal. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes.
I'd like to propose a motion to have the town attorney and staff work with Valamo on the details and end of life, all that goes along with this project.
Contingent upon receiving the funds.
Yes.
Okay. Is there a second?
I'll second.
Motion's made and seconded. Those in favor, please say aye.
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 Aye. Any opposed? That motion passes.
Thank
Thank you. Good luck with the application.
Yes, thank you.
Looks like it'd be a good project. Item 7I on the agenda, Polar Lakes Park flagpole planting.
Yes. Flagpole the flagpole area up at Polar Lakes Park, it's a little bit in disrepair. Solicited a proposal from Laux and Associates to give us a new landscape design for the flagpole area. This was reviewed by the Park Board at the February meeting. The agreement on page 103 of your packet and was recommended for approval. Since that time, we have asked Laux and Associates to put together a proposal that would include the designing landscaping for the town hall after it had been relocated. And so that proposal was updated, and where do we have that?
Supplemental.
Okay.
It's on page 18 in the supplemental. Is that what you're looking for?
Here we go. So Laux has put a proposal together which would propose for a fee not to exceed $6,360 to provide the services to design the landscaping for both the town hall and the park flagpole area, put together construction plans and specifications, prepare a final cost option. Again, not to exceed a total of $6,360. And that's for both projects. The Park Board did recommend approval of the park flagpole project at their last Park Board meeting.
And but the specific action item for the board here is just to authorize expenditures for the flagpole, right? Would the EDA approve funding for the town hall portion?
Correct.
Okay.
So that's correct?
Okay. Any questions?
Nope.
Is there a motion from the board?
Make a motion based on the Park Board review and recommendations, approve the flagpole planting plan proposed from Laux at an average rate of $120 an hour, not to exceed 8 hours, with funding from the Polar Lakes Park Fund.
Is there a second?
I'll second.
Motion's made and seconded. Those in favor, please say aye.
Aye.
Aye. Any opposed? We have one added agenda item, and that's to approve a special board meeting for April 12th. And that's for the Park Board liaison and the EDAB liaison to attend that joint EDAB and Park Board meeting. Is there a motion to that?
I'll make a motion to approve the special meeting of the joint EDAB and Park Board meeting for Tuesday, April 12th at 5:30 at the Town Hall.
Is there a second?
I'll second.
Motion's made and seconded. Those in favor, please say aye.
Aye.
Aye. Any opposed? That motion passes. Item 9 is open time. Anyone here for a statement or comments?
Just participating.
Good, glad to see you. Item 10 is to receive agenda materials and supplements.
So moved.
Is there a second?
Second.
Those in favor, please say aye.
Aye.
Aye. Any opposed? Item 11 is adjournment. Is there a motion to adjourn?
So moved.
Is there a second?
A second.
We are adjourned.